being able to access information that they have a legal right to. And that, you know, I'm a criminologist, I've contracted, or been seconded into the New Zealand Police and worked in the Ministry of Justice. I'm really sympathetic to that position. You know, it must suck as an investigator to know who you're going after, have a warrant. It's not always an easy process, and not being able to read the information. But I think there's targeted solutions that we need. We don't need to, and we shouldn't be trying to weaken everyone's security, right? So one of the things we hear from other politicians in other Five Eyes countries around, you know, math is bad, terrorists are using encryption, the UK Home Secretary, I don't need to understand encryption, I just need to do stuff about it, is not helpful. And so, you know, because everyone frames this as a national security issue, I guess the first thing I would implore everyone is it isn't. You know, we hear privacy versus security. It's not privacy versus security. It's national security and public safety being traded off, balanced, John, you know, and measured against technical security, human security, and human rights. Right? Like that's the balance. It's about citizens and their information and organisations and their information versus the state's interests in trying to keep us safe. Really, really quickly, I'm just going to say backdooring encryption protocols and services, it's a bad idea. It's a dumb idea. It sounds easy and nice to a politician. You can say something strong. Key escrow is another idea where people can surrender, you know, if you're an online service provider, say your WhatsApp, you give some person or organisation a copy of a key to unlock content when a court tells you to. I don't know who I would trust to keep those safe, and I don't think there are too many examples of governments doing the right thing when they lose the not digital version of those things, like the Transport Security Association in America lost a copy of all the master keys to all the padlocks you put on your luggage, and it's available on GitHub. You can download them and print them, and TSA went, oh well, I mean, we can still get at them. That's what we care about. No need to change. And definitely banning encryption products, which is something that sometimes gets bandied about in other countries. Also a bad idea. New Zealand is a technology taker. We, of the 380 something encryption products and services in last year's survey, 3 of them were from New Zealand, and one of those is a contribution to an open source protocol. So we can't ban things. We're a technology taker. And so I'm really interested in trying to have a bit of a debate and policy discussion and steer things away from bad ideas that sound good to people who don't have to pay for them to actually what are tricky and complicated policy issues, like actually solving mutual legal assistance across countries. Hard, worthwhile, helpful. Also lawful hacking rules. Actually being able to, you can't access that information.
We'll come back to you. Thanks, Ben. Ian.
Great. Hi. Kia ora, koutou. I'm not really used to using these things, but can you hear me at the back all right? That's good. Cool. Can't get away from being a lecturer. So, welcome. It's a really good chance to be a member of this panel and see this range of viewpoints. I guess I was thinking about this last night, and my feeling is that I'm a technologist, I guess. Like, I've done all the jargony keywords, which I put into that bio there. A lot of them about basically cryptographic mechanisms to try and protect people against people breaking in or people misusing the techniques or stuff like that. But I guess my main viewpoint is that technology isn't the answer, crypto magic isn't the answer, and that it's all about people and organisations and governments and laws. And like Ben, I actually support encryption everywhere. And I think that a lot of the debate here is about terrorism, a lot of debate is about criminals and so forth, but I'd like to talk about another group that use crypto currently, and years ago, before the internet was a thing, would have actually benefited a lot from crypto. And I guess I'm one of them, actually. So there are people who operate in the dark corners who try and get change in society. And they do things that are illegal at the time that later become legal. So for instance, I had a honeymoon recently, and I was in a hotel room. And it was a honeymoon, so you can imagine what happened. But my husband and I weren't arrested by the police. I'm not blaming the police here, but I wasn't arrested. I didn't lose my job or anything like that, which would have happened probably 30 years ago. And if we had had this debate and we had banned encryption, we had banned a lot of these tools that are making their ways into ordinary people's hands, then we could really have a bad situation. From the technology side, I think that technologists have a contribution to make, which is working with other people. And this is a great chance to start that kind of debate. And I know that Internet NZ have been doing that for a while, which is great. And not just for those personal reasons around why I think it's really important to have, in terms of protecting my own privacy and liberty and rights and things like that, but also because I think that the focus is wrong. It's focused on encryption. That's only a very small part of the problem. It's systems thinking that we need. It's looking around it. It's using our resources in the best way possible so that we're not focusing on the wrong problem. And I'm not alone. The International Association of Cryptologists as a whole oppose mass surveillance. That's a whole other issue. But they also oppose the watering down of encryption standards. This has been a problem. It's one of the techniques that has been tried is to say, you can have crypto, but it's sort of half, well, I was going to say half-assed, can't say that, but it's not great crypto. It's okay, but it's okay for large organizations to break, which is fine if you believe it's just large organizations that have your interests at heart, but there are lots of criminal ones out there and lots of other ones that don't. So it's really a hiding nothing there. So my takeaway is that I think it's about engaging law, it's about looking at oversight on these things, it's about not breaking things that work, basically. And I'd love to talk about it a bit more with the folks here. Cheers.
Thanks, Ian. You left 2 minutes, which I can fill, but it's really interesting when we frame this discussion as a thing that's happening now. All of the questions that the first two speakers have hinted at, can we break, can we prohibit it? Can we have backdoors? Those discussions happened and concluded and failed 30 years ago. We had PGP, Pretty Good Privacy, attempts to ban an encryption code foiled by printing it in a book, which then received First Amendment protections and was transmitted outside the US page by page to get away from prohibitions on exports of munitions. We've had the Clipper chip, Clinton's idea of escrow and mandated backdoors, which was dead in the water because it didn't work and it was hacked, let alone getting the kind of industry support for the uptake. Ryan, what do you see happening in this space that's different from what we've seen in the last 30 years?
I think, one of the trends that I'm witnessing, and personally, the University of Waikato, we're also researching with Auckland and Unitech and the Cloud Security Alliance, is returning control to users, because there's a increasing user demand of some control over their data, but it's a bigger problem than that. So from a toolmaker point of view, personally, I'm quite passionate about making computer tools that empower people with some ability to take control of their data and their assets. That has a lot of implications. For example, we have, I make this poll every time I speak in public occasions like this. How many of you know how to help yourself after you are hacked? Yeah, that's not the majority of the room, right? So therein lies this opportunity for tools to be created to help people to help themselves, right? It's just like, CCTVs or locks and keys. The same thing needs to be done in the software space. We need to have ability to help ourselves. And that can be done with great tool making. But tool making exposes even more problems. For example, when we talk about encryption, we put everything together as this or that, or ones or zeros, but we never really think deeper into the process. For example, when we are talking about encryption, there are three main stages of the life cycle of information. First is when you communicate, the privacy of your communication. And after you communicate, sometimes you want to store the message, so the privacy of the storage. And then the third one is the most interesting one, which actually ties into the law enforcement, is forward secrecy. How do you, allow some form of law enforcement to help you, maybe even as a victim, or even to solve a very tough case, like a murder or something like that. So these three stages are quite challenging. There are many different proposals in the world of applied cryptography, which I'm researching in. One of it is in the area of privacy preservation, called homomorphic encryption. So homomorphic encryption is trying to allow you to process encrypted data without ever decrypting it. So you can imagine it's like you're going to a bank where your bank teller is your nosy friend, and you don't want that nosy friend to know about your bank account balance, and they will never ever know about it because you have homomorphic encryption applied into the system. The other thing that when we are designing tools around helping people to help themselves comes in the differences of and the diversity of the people that we face. For example, I'm Asian, right? So in Asia, we particularly in Asian cultures, privacy is something that is not really the key thing, but rather secrecy is the key thing. So family, dirty laundry in the family will never get out, that kind of things. But at the same time, my mom would be asking me when I'm having my next child, even though we have two, and before that she would ask when I'm getting married, and conversations would begin with, so what's your son doing right now? Are they, so it goes into the so-called privacy as well. There's a cultural aspect of things. Is privacy secrecy, So there are even different stages of our lives when we are designing tools. Like one day, I can feel, I get freaked out by some news, and I said, I'm not going to let Google, I'm going to close all my Google accounts right now. Yeah, because it's tracking all my emails, and then the next day I said, I think it's quite useful to have a Google account because I want to use Google Maps. Yeah. So how can we design something that allows this thing, or even when the weather is good in Wellington, how I feel like the preferences might change. So these are some of the things that can affect us. And with regards to monitoring and the sentiment towards that, there has been this kind of public image about the governments and the intelligence agencies and the policing, law enforcement agencies monitoring things. I believe there is more than that. The tools that we use are also looking at that. The big companies that we use every day, the search engines, the social media accounts that we use are also monitoring us. Are we setting the same standards on these companies as we are against the governments? So that's my question.
Thank you. Thomas, interesting question posed there. Are we worrying about the wrong thing? Should we be more worried about Google and Facebook than GCSB and SIS and New Zealand Police? And if you're not a terrorist, why do you care if they can crack your encryption?
Kia ora, everybody. We've already heard people saying that breaking encryption is hard and that technically it's very tricky and so on, but that doesn't actually stop governments. Governments are quite prepared to just charge in no matter what. And one of the examples we can see of that is the recent customs law, which says customs can force you to unlock your device at the border. Now, I'm not going to get into the details of why I think it's a really crappy law, but it's an example of saying that government doesn't have to come up with an all-encompassing, overwhelming solution to the whole problem. They can just nibble away at the edges, and that will change things as it goes. And I think it's probably because I think that we've got to realise that surveillance is actually not the most important thing for our government and for our society. We're much more interested in things like well-being and political freedom and so on. And they're actually rearranging society and technology so just so that governments can surveil us if they want to. It's probably taking the wrong approach. It's a tail wagging the dog. Because as information is increasingly becoming digitised, the amount, if you look at, don't think about it as the amount of information, think of it as the percentage of information about you. 30 years ago, very little of it would be digitised, and now we're getting increasingly closer to more and more of it becoming digitised. At the same time, we're putting microphones and cameras in our homes and we're carrying them around and so on. So what I think is that we need to get away from this idea that just because the information is out there, just because it's stored digitally somewhere, means that the government should be able to access it, even if they can prove cause. Maybe we need to start thinking about what information we should be able to keep secret. Maybe we should be allowed to keep secrets of various sorts. And that leads into the second point about, in our current environment, crime is falling, or at least it was according to statistics I last saw. And at the same time, we haven't had a terrorist incident in New Zealand for over 30 years. This is not a major pressing problem where things must be done soon. And anyone who tries to tell you that is just fear-mongering. And that's finally the point I want to make, is that when I look at the world now, when I look at what scares me out there, it's not terrorism and crime. It's climate change. And the other thing that's worrying me a lot at the moment when I look overseas is the rise of totalitarianism and fascism. And I don't just mean in China, I don't just mean in Russia. I'm looking at what's happening in Spain. I'm looking at what's happening in Australia with their concentration camps and their gag laws about what's happening in them. And of course I'm looking at Donald Trump and the United States and the rise of fascism there. And you've got to say that this is not a time to be strengthening the state. This is not a time to be making the state stronger and giving them more ability to look at what we're doing and how we're doing it and why we're doing it and when we're doing it. This is the time to say, actually, we should be limiting what our state can do while we can and before we go down the same path that some of these other countries are going.
Thanks, Thomas. Excellent. John, what would you like to say?
So I guess we think of ourselves as sitting in a rather unique place in this debate because we are both a protector of our customers' personal information and, I think right now at least, the principal facilitator of interception for law enforcement and security agencies. And we've seen a dramatic change in the last 5 years in the way that our customers, the way that New Zealanders think about digital privacy, and that is throwing up a bunch of these questions that I think it's right we debate now. And I think our assessment, it's an open question for debate, but our assessment is that New Zealanders on the whole are more worried today about their digital privacy than they ever have been before, and they are more suspicious about digital interception practices by law enforcement agencies than they ever have been before. Now, I think, again, our assessment is that trees up to a position where most people, in fact, I think all people are against and won't accept mass surveillance, but most people agree with the principle of limited interception where there's a lawful authority. And that, I think encryption is an interesting microcosm of that, whether that is the right position or not, because a big policy issue that we grapple with is differential application of interception laws to different providers on a technology basis. And so we have an act today that sets a different set of rules for Spark as a network operator than it does to Viber or Facebook Messenger or WhatsApp. And the reason that's important is because what we're seeing every day is a really rapid shift away from traditional telecommunication services to over-the-top applications that are often served from offshore. And so I think personally the really interesting question sitting behind all of this is how do you get to cross-border jurisdictional interception framework that can be consistently applied across industries and countries? And that's a question I don't know the answer to, and open question as to what, say, New Zealand will have in it. I guess when we reflect back on what our position is. As our customers' views have changed, we have also reviewed and refined our policy position on interception and encryption. It's a living and breathing beast, so it does change and it is changing, but right now it goes something like this. Our first responsibility is to our customers, and so our default position is we will not share personal information without lawful authority that requires us to do so, or in a very rare case where there's a life-threatening situation. We are also, though, a responsible New Zealand organisation, and we have long-standing relationships with law enforcement and security agencies, and so we will not frustrate their attempts to apply their lawful powers. And that leads us to a view that we've been pretty public about in the last year in particular, which is we don't want discretion. We won't apply discretion to information requests. We respond to lawful authorities. And that means that our legislation needs to be absolutely unambiguous and comprehensive about what those powers are. And it also needs to apply them in a way that is principle-based and technology neutral. So we think of broader interception in those terms. Our position on encryption is going to be broadly the same. That is that we are dealing with communications fundamentally. They may be encrypted, but they're communications. And so law enforcement and security agencies should in principle be able to apply the same lawful authorities they have today to communications in the future. Just because the technology used to deliver those has changed shouldn't fundamentally change the legislative principles unless we think they're wrong. And that is a whole different debate. And providers of those communications should be required to comply with lawful authorities. They, just like the rest of us, operate in a society that is ruled by laws. None of us get to ignore them. That said, they should also have a choice as to how they do that. I am confused by this debate about whether and how, legislatively or otherwise, governments should mandate the form of decryption or interception. That is not their role, and frankly it hasn't been their role. In our experience, they've never tried to dictate to us how we provide interception across our services, and the same should be true in the future.
Thank you. Declan.
Yeah, thank you very much. I guess following on from, there's a sort of a theme, I guess, that's being teased out slowly as it's worked its way down the panel towards me, and there's a lot of discussion around governments and government policy and lawful interception and all of that kind of stuff, which I think is extremely valid and extremely important. But I guess there are two key things that I'd like to sort of say. And first and foremost, I absolutely agree with the other panel members and yourself, Don. I think that the encryption horse is well and truly bolted. And the reality is that modern economy is entirely underpinned with encryption. And I'm not just talking about the back-end core. I'm talking about every single person interacting financially is dealing with encryption. Your cards, e-commerce, web banking, everything is underlined with that. So the concept of degrading that or taking that away, I think economically is a non-starter. So one of the next point that I think is really very, very important is that if we take away the concept of blanket privacy and blanket access to data, we find that, and certainly myself dealing with incident response, not just in my current role, but for nearly a decade going back, there is an enormous amount of data that people have, and that has an economic value. So we're seeing the largest organisations, the Googles, the Facebooks, all of these people, all of these organisations, their entire economic model is based around their data, and their users' privacy information is what makes them valuable. That's the special sauce. So we see a lot of technological advancements around, access with Gmail, the ways that they're protecting people's accounts. Same with Facebook and Facebook's protections, and even WhatsApp, even though it's point to point. There's still they're protecting that information because that's their commercial information. They don't want other organisations to get it. They don't want people to hack their information because that's theirs, that's their intellectual property, and they don't want other people to get access to that. And that's all fine and good now, but there are a couple of things, and that's the privacy statements and settings in all of these organisations are entirely changed at will. The users have no control over that. They can check out of their economy and their friend circles in modern society if they want to, but the reality is that they won't. And if you think back in time, there are these giant companies that have come and gone. Digital Electronics and Sun and all of these organisations that have come and gone over the years. Well, what happens when that happens to Google, when Google's no longer a thing, or when Facebook's no longer a thing? That data is still going to be there. And we're seeing that now already with all sorts of random applications and stuff that people are using on their phones or whatever else. They put their data into it, and then that'll just disappear. And I think that if we're going to be talking about the sort of the privacy and encryption and all that kind of stuff, well, encryption is a very it's a smaller part of a wider picture. And I think that it's worth widening the aperture, I guess, of what we're looking at to think on a systems perspective. I know that was mentioned earlier. I apologise. I think it might have been you, Ian. And I think that's a really important way to look at this. And that's the two things I think are probably most important.
Thank you. Cheryl, since the Enigma machine, states have been trying to protect communications and other states have been trying to crack them. Under what kind of conditions? I'll leave my questions to later. You can tell us what's your perspective.
I mean, my starting point was that, as you said earlier, John, this is not a new issue. The going dark problem in one form or another has been around for a long time, but I think the San Bernardino terrorist attack brought it into much clearer focus in the public mind with the subsequent FBI Apple court battle. And unfortunately, or perhaps not, that was never resolved legally, at least not at any kind of appellate level in the US, because the FBI found a way to hack into the phone of the shooter. But I think what it did do is to help us and to focus on what's the policy problem that Ben mentioned earlier. And I think that the problem is not, or it shouldn't be, about government agencies having exceptional access to all encrypted data. The question should be, how can law enforcement and intelligence agencies get enough information to do their job, not ensure that they get everything they might ever seek? I think the first point is to narrow down the policy question, and that does get a bit lost in the rhetoric, particularly from governments in the immediate aftermath of terrorist incidents. But narrowing down the question helps us to assess possible alternatives to legislative requirements for backdoors or whatever other options might come up. I wanted to briefly just touch on some legislative solutions in other jurisdictions. And in the UK, their Investigatory Powers Act has new provisions which authorise the government to compel private companies to create and maintain the ability for government to access communications. How those are going to work in practice has not yet been tested. As we know, in Australia, following the meeting of the Five Eyes Attorneys General meeting earlier this year, the Australian government has come out aggressively saying it will legislate for some form of assistance. The Prime Minister says not backdoors, but appropriate assistance to law enforcement. Interestingly, in Germany there is some legislation in place already, but just this morning there was an announcement that there will be a new law that will force device manufacturers to include backdoors within their products. It will target all modern devices effectively, cars, phones, computers, and so on. In New Zealand, as John mentioned earlier, we have TIXA, which is relatively limited in its operation in that it concerns only the encryption used by entities subject to the Act, and I'm not sure exactly how many they are, but probably not a large number. I expect New Zealand-based and readily subject to our jurisdiction. and only applies only to encryption services provided by that provider. So it can't compel providers to encrypt someone else's system. In the US, there is some legislation in place and constant moves to reinforce that. But the one thing I wanted to focus on before I finish is that despite what you might think from the media coverage, there isn't a uniform view on this question about backdoors, either from one jurisdiction to another or across all law enforcement and intelligence agencies. So in the US, President Trump, as you would expect, said about Apple, who do they think they are? Attorney General Jeff Sessions has expressed strong anti-encryption views. Former FBI Director James Comey led the charge against Apple. Current FBI Director hedged his bets at his confirmation hearing. The CIA Director Mike Pompeo has conceded that a backdoor would lead terrorists to communicate via alternative means, so it's not a complete answer. And significantly, the NSA Director Administration, Mike Rogers, has publicly adopted a pro-encryption position, and likewise former NSA Director Mike Hayden has spoken out about the benefits of encryption. And that position is reflected in the UK too by a former director of GCHQ, and both NSA and GCHQ are the counterparts of GCSB in New Zealand. So former director of GCHQ, Robert Hannigan, has strongly supported encryption and spoken against building backdoors. And likewise, Dr. Paul Kilworth, the current Deputy Director of Strategy, has said similar things. So what that seems to reveal, in part anyway, is that there is a difference of approach between law enforcement agencies and some intelligence agencies, and particularly a difference in approach from signals intelligence agencies. And you might say that they are just more enlightened, but you might also look at, is there a particular reason why that's so? And I think if you look at all of NSA, GCHQ and GCSB, they have a dual mandate to protect the nation's information security by defending against cyberborne threats, so a kind of assurance or defensive role. And they also have a role to conduct active or offensive cyber operations. So they both need strong encryption and need to break strong encryption. So that puts them in a somewhat different position, I think, from law enforcement agencies. And for GCSB, the public embodiment of the assurance function is the Cortex program, which helps organisations of national significance to counter cyber threats. Now, I'm not aware of any public statement made by GCSB on this debate, and I'm certainly not speaking for them, but it does seem to me that it might be the case that they feel that current protections in TICSA, for example, are adequate for their purposes. And I certainly haven't seen anything in New Zealand context about the law enforcement view on this issue. But all of that leads us to the question of what's the scope of the problem. And I think in New Zealand, as elsewhere, both law enforcement and intelligence agencies have not adequately defined the breadth of the problem. And without that knowledge, what are the issues? How commonplace are they? Without that knowledge, I think it's very difficult for us coming at it from a public policy view to decide what's adequate in terms of protection and what's proportionate to the risk.
Thanks, Cheryl. That's fabulous. And I think that a couple of points you kind of touched on, the proportionality underpinning obligation, which is, of course, a big part of European human rights law in this area. But just in terms of rounding out the international perspectives, Cheryl's focus, I think, is naturally on our Five Eyes partners, but the Dutch government last year took a position in quite the opposite direction that we've seen at some of the Hawks, and said that the Ministry of Security and Justice said the government believes that it is currently not appropriate to adopt restrictive measures against the development, availability and use of encryption within the Netherlands. They opposed the introduction of backdoors, and they have actively promoted the use of encryption as a net benefit for that economy and that society. So, it's interesting to see different kind of cultural backgrounds and the different answers that we get. I want to come back to John. You mentioned, John Wesley-Smith, you mentioned in your presentation a couple of baseline measures of adequacy of the legal environment. I can't remember exactly what they were, but I wanted to get your feeling, and some of the other panel members, as to whether we are in about the right place in terms of the regulatory environment for allowing law enforcement intrusions into our digital communications.
Yeah, I think the ones I mentioned were principles based in technology neutrality. I think proportionality is another one that you would add. I think most people would agree with that. As for the current framework, I guess if I boil it down to that simple proposition that Cheryl just outlined, which is we're not talking about all information, it's a subset of information that enforcement and security agencies require to do their jobs. I suspect that right now we're at not a bad, healthy balance. I personally think, though, that's because the problem we have is we don't have a technology-neutral set of legislation or legislative powers right now, and frankly we're just relying on the fact that the main providers of communication services are still New Zealand-based right now, and are network operators with long-standing relationships with those agencies. Now that is going to change, and whether and how we keep that balance as communication provision shifts to WhatsApp and Viber and Facebook Messenger, who are all organisations based outside of New Zealand with minimal physical presence here and very shallow relationships with our government, is an open question.
Thank you. Just a reminder to our participants online that if you want to submit questions, breaking the code is the hashtag, but if you could just do it by going on Twitter and sending a message to @NZPrivacy, those questions or comments will come through to me. Then Internet New Zealand's position on the adequacy of the current legal framework and the endurance. I mean, what's coming next? I'll come to Ian afterwards. I mean, is quantum computing going to render this whole discussion obsolete? But tell us where we are at the moment, Ben, in terms of the regulatory and technological environment, and then maybe look a little into the future.
Sure. I'm going to let the academics deal with quantum, because that is way over my head. I think the current legal frameworks we have are pretty good. I mean, one thing I would note is John's point around over-the-top messaging providers. So one of the challenges with TICSA, I believe, is that requirement for a network operator to be able to decrypt something. So Spark legally can't make a competitor to WhatsApp because they can't build an end-to-end product. Like, no New Zealand network operator can build an end-to-end encrypted product. So if that's what people want and that's where people are going, there's no New Zealand provider for them to go to. And so I get why we have that, but the consequence over time, as John says, is that New Zealand network operators will see less and less. I mean, which is a challenge. I guess would be the one thing I say. I mean, I think TICSA's about right. I'd like, obviously, the most recent intelligence and security bill into the NZ had a couple kind of firmer points we would have liked to see inserted around actually the government committing to not doing mass surveillance. But funnily enough, no one took that one up. But yeah, the law's pretty good at the moment. My main concern is that reactionary drive. But more importantly, New Zealand, if the other Five Eyes countries take the initiative, like Australia has, and they introduce bad law, and they are bigger economies, and we're going to be forced into those spaces anyway. So I'd much rather see New Zealand adopt a really principled, useful, constructive international framework and drive the Five Eyes on a race to the best, not a race to the bottom.
Thank you. Thomas, can I just, before we move on to look into the crystal ball or go down the wormhole of quantum or whatever, your observations on the current state of the law, would you roll it back? What would you roll back? What would you replace it with?
That's hard to say. I think the law at the moment isn't as bad as it's actually not that bad in some ways. The problem is that the way it's applied is still a bit opaque. For example, civil liberties, we actually support the idea, we like the idea of criminals being stopped. We like the idea of the police being able to, under proper authority and with proper guidance and oversight, everything else, be able to get at that information to stop and catch people. What we are concerned about is two things really. There's a lot of bits in some of the surveillance laws and spying laws which to me look like they can be used very widely, and I don't quite understand how some of these orders and arrangements they can be set up are actually used in purpose. So getting some more surety about that would be good, because one of the things that we're concerned about, and actually I actually heard Nicky Hager talk about this, is that people's fear of surveillance, people's fear of mass surveillance is actually as limiting as the reality of it, in terms of stopping freedom of expression, in terms of limiting people. And the other issue for me, I guess, is that I find that the fact that one of our main surveillance agencies is also involved in the Five Eyes, it's getting out of civil liberties a little bit, I see that it leads to a two masters problem. And I have doubts about, some of the decisions of the GCSB are being taken in favour of the Five Eyes rather than in favour of the people of New Zealand. So that's always an issue for us as well.
Thank you. I wonder academics could shed some light on the technological limitations of these products. Those of us who look at this area, who comment, who organise these seminars, we say, oh yeah, and there's Messenger and WhatsApp and Signal end-to-end. I have no idea whether those encryptions have been broken by intelligence agencies. I have no doubt that they will be attacking them hard as we speak. How does this game of cat and mouse go?
So back to remember the 3 points that I mentioned about communication, storage, and future or forward secrecy. So WhatsApp or any other communication device that are end-to-end encrypted can keep the privacy of the communication pipe, but at their servers still has to be decrypted for it to purposefully work. So does online banking and many other things. So ultimately, we need to understand a little bit more about the whole process and not apply a silver bullet kind of methodology on that. And then on your point about the quantum computing, if I may, there is an international effort right now to be ready for post-quantum cryptography or PQ crypto. Right. So if you can't fall asleep at night, you can just search for PQ crypto, and there are a few nice talks and PowerPoints that talk about it. It's talking about what would crypto be like and how it becomes hell breaks loose when quantum computers, all-purpose quantum computers can work. And there has been reports and forecasts that say that it will be a matter of about 5 years to 10 years time frame where we see a first rudimentary general purpose quantum computer. So it's going to happen. It's not just going to affect crypto or encryption. It also will affect things like Bitcoin and many other things, or even blockchain.
Yeah.
Okay. Oh, does that work? Yes, that's great. Okay, so I guess that this speaks to the idea that maybe encryption is going to go away. So with quantum computing, a lot of encryption is based on factoring big numbers. Okay, and quantum has this potential of allowing you to factor large numbers if you can phrase the question right, and you have enough qubits, which is the sort of the processor speed or processor power of these things. And it's still a way away that we're going to get that. But even if it goes away, that you can factor a large number, there are various crypto protocols that don't rely on that at all. So there's one called zero knowledge proof, which is basically I want to prove to the person at the back there that we know a secret. So we ask each other tricky questions, like 20 questions. And after we've done this about 30, 40 times, if you can answer yes or no in the right order, based upon my questions, I think you probably know the same secret as me. Now that's not affected by factoring or anything like that. That's a technical. So there's technical solutions. But again, I think this debate around encryption, we have to, I like what was said earlier, that we have to go wider, and it's a systems problem, and it's looking at the rights and responsibilities around how we tackle breaking into someone's communication. So the easiest way to get into your communication, John, would be to get on your phone or encourage you to download some app that's going to pull out your WhatsApp messages just directly from the phone. Or I can just shoulder surf you and take pictures. That's another one, I guess. Various things like that. And so then the question comes, what are the police allowed to do, or what are X allowed to do? I don't actually care whether it's the police or an organisation or what. It's what does the law say? Is the law also going to be chocker full of technology that's going to go out of date? So it was raised earlier that some of our law is very technologically based. There was the Creative Performance Bill a few years back, which was about copyright, and it had things about librarians being able to break your DVD encryption for you, and it was very much tied to that. That was bad law. So the question is, how do we phrase the law in such a way that captures our intent, and then how is it tested in courts actually, or what did that tell us about things? Okay, cool.
Thanks, Ian. Ben, did you want to add something to that?
I just want to say, just a follow on from that, is it's about the law, but it's also about the process. So a good example of what I would say is good law and good law enforcement is the FBI using a network investigative tool to decloak about a dozen people who were trading child sex abuse imagery. And I'm sorry, I know I'm using the pedophile and child sex abuse imagery example, and I always try not to. But they locked up 50 people and they rescued 32 kids. And I'm really okay with someone building some tools. What I'm not okay with is them saying that tool and that exploit we used is secret and can never be disclosed in court. If it's good enough to use for a law enforcement purpose, then you disclose it in court and you get it patched, and then you burn the tool and you move on and get another. And that's a part of that discussion that just doesn't happen at all. And I think needs to happen.
Ben raises a point that I wanted to mention as well. Post San Bernardino, there was a lot of discussion in the US about what was a kind of more targeted solution to the problem, bearing in mind that in that case, the FBI was able to get someone, and the speculation was it was an Israeli company, to hack the phone in question. And one of the proposals that's come out of a lot of that discussion is to establish clear rules around government hacking, because that's a kind of narrow, confined solution to a particular problem. And what it needs, though, is to be much more clearly regulated than it is at the moment. And linked to that is Ben's point that we need, and this is particularly so in the US, obviously, but we need clear regulation about how government agencies use those previously unknown software vulnerabilities for their own use, rather than disclosing them so that they can be fixed. And certainly in the US there is a process called the Vulnerabilities Equities process, I think it is, which dictates what the government can do with those, but it's not codified in legislation. And of course that raises the broader question about that arises from having a government agency that does both cyber offensive and cyber defensive activities. the possible conflicts for them in dealing with those kinds of vulnerabilities that they discover or buy.
So the agencies that you oversee, Cheryl, they need an express, judicially issued warrant to intercept communications. Are you saying they do not need any special positive legal power to try and hack an existing vulnerability?
No, I'm saying that any activity of that kind would require a warrant. It's probably more specific controls around how you use vulnerabilities, perhaps a clearer mandate in our legislation for that kind of C&E function, which is broadly captured in our legislation, but it isn't spelled out in any kind of detail at all.
Thank you. I guess, Declan, you would expect that if a vulnerability is identified by intelligence services that they are using to exploit, that it would be notified to CERT. That must be quite a sensitive dance there, because to protect the economy, we've got to get these things patched. Do you wait until the law enforcement or intelligence services run its course, or are you able to contribute to that discussion?
So we run a coordinated vulnerability disclosure program, and the details of that are on our website. It's open to anybody, and it's one of the things which, since we've been launched, has been steadily increasing the number of people that go to it. As an organisation, we absolutely advocate for information security, and we work really hard to get these vulnerabilities fixed. So that's 100% of our focus, and our processes are purely there to balance the needs of the people which are reporting those vulnerabilities to us, and protecting their identity where they're uncomfortable, engaging directly with the vendor, etc. And also the needs of the people that have built these systems, so that they can get that get things fixed. People write code has problems, it has dependencies, it can take time to fix things in a meaningful way, and so we have, by default it's 45 days, but we can negotiate with organisations where they say, hey, it's actually going to take us a longer period of time to fix that vulnerability, and so that's with that service, that's where our focus is. Absolutely.
Thank you. Then Internet New Zealand, in its paper, promoted lawful hacking. That sounds like an oxymoron. Do you want to explain why you would be in favour of such a thing?
Well, so I guess the main point is, if law enforcement or surveillance agencies have a lawful legal right to information that they're technically barred from, at the moment the main two choices are letting them hack the particular bit of information or the device for the whatever to get the information, or weakening everyone else's devices, and I much prefer the first. There are costs associated with that, there are capabilities, there is obviously a amount of when is that appropriate, when is it not, how do you define if it's serious crime, how do you define it? There's things, but the basic premise of, rather than saying I have a legal right to the content, show me the content, is I've got a law, as New Zealand Police, they have a warrant, they've seized a device or some information, it's locked, give it to the techs will unlock it for you, say here's the plain text back on that particular case. So I'm pretty comfortable with that. That's kind of what happens at the moment anyway. It's mostly around process and transparency of that process is what's needed.
Thank you. I think we should move to questions. I'll take one from the internet first. Is there any appetite for regulations for controlling VPN operations in New Zealand as have been implemented in Russia and China? Anybody aware of... John, have you heard of any such thing? No? Ben?
No. Bad idea.
We're not regulating VPNs and we don't like it, so thank you, Hamish McEwen, for that. Human person.
Yeah, I'm good.
There's a microphone coming to you, so if you do want to speak, could you just wait until one of our runners gets your microphone and if you could introduce yourself. Thanks.
Thanks. We've had a large focus on the government and stuff like that, and I'm happy I don't live in the States. I don't worry about that so much. But Ian and Thomas touched on the personal safety aspect of encryption, and there's things like Women's Refuge has the Shielded app where women can safely report domestic abuse without being tracked by their partners. And I know Declan's talked about similar things before that I've seen at CERT. I was wondering on views on the personal safety sides of encryption.
Thank you. And I will throw that, I just want to bookend that with a question from Twitter. This discussion has focused so far on government and corporates having access. What about the more personal level of individual and family safety, protecting women who face issues with intimate partner violence, stalking, etc.? Who wants to take this one? Declan, please.
I might jump on this. So, at CERT, we have all sorts of people and organisations reporting the information security issues that they have had to us. And as Kirk mentioned, some of those do involve, unfortunately, personal safety. The encryption and not just the encryption, but the protection, the confidentiality, the non-repudiation of people's data and people's devices is more and more important every day. And I always go back to the example of a mobile phone, because it's not actually a mobile phone. It's a supercomputer that is also a bug, that is also the most incredible device you could possibly imagine. It tracks where you are, who you talk to, what you say, where you go, what you're interested in. The apps on there have access to all of this information. It's an absolute goldmine of all sorts of extremely powerful, valuable, and dangerous information all at once, mixed up together. And so, to specifically go back to the notion of personal safety, that information, when it is in the hands of a democratically elected government with laws and policy and transparency and panels of people that care deeply, talking about the ins and outs and intricacies of all of their decisions, is one thing which is very admirable. But when it is, a software company that is disregarding potential personal safety or other issues associated with users to make $30, euros, whatever it is, a month for a spying application that can go on someone's phone to, protect their children or whatever it is, and things that people say for that, it really brings the notion of this stuff into light. And when people talk about, encryption and backdoors or working through things or law enforcement's ability to do things, or even, and I'm not saying that anything that you said was wrong, Ben, or that I disagree with you, but, people write code, people make mistakes. Mistakes cause vulnerabilities. Vulnerabilities mean that the wrong people can access this personal data, and it's having a nation state or a legally and democratically elected government accessing something is one thing, but those vulnerabilities still exist, and that's why that's why we have our coordinated vulnerabilities to go to try and fix it. But where it goes wrong, the cost is very, very real. And if you can imagine what would happen if someone that you didn't like knew where you were, who you were talking to, what you were saying, everything that was said around your phone, everything that came in view of that camera, and were gaslighting you or making you feel crazy because of what they knew about you and your life, that is an absolute nightmare scenario. And so having these controls and protections in place for ordinary people built into these devices in every aspect is extremely important. And it's not just about the economy, and it's not just about national security. It is the absolute personal safety of people that engage in the modern world.
Thank you. Ian, you've reached for a mic?
Yeah, I was going to say that I think that the personal is really important. And I was thinking actually about the Privacy Commission and some of the reports there about some of the problems that people have around privacy. And often it's with friends or friends of people who work with people and things like that, and they have a big impact. And the Women's Refuge is a great example of where personal safety is really important. One of the things I worry about a bit, I think it's great that we're adding more security into our devices. I worry, and I don't know the answer to this, about making it usable for people and allowing people to actually understand, or making it match their mental model of what they think is going on, so that I don't end up trusting something that's not actually trustworthy. I think it's secure, but everyone, I imagine a number of people on this panel do tech support for their families, and people aren't stupid, but they just have different mental models, and they'll post private things to their Facebook page, which they think they're having a private conversation with your dad. But technology, again, isn't going to solve the game by itself. Education can solve ours. It's a mix. It's also about educating our developers in general, our software engineers, so that they understand security and how to actually create more usable security solutions, I think. Yeah, that's my take.
Thank you. Do we have any other questions or comments from the audience? Thanks. We'll come back to Sophie over here after. Thanks.
Sorry, I work with the digital child exploitation team with Internal Affairs, and I've also had previous experience working in counter-terrorism and organised crime within Ireland. And the thing I would say is I don't agree with actually having backdoors to encryption, and I'm coming from 20 years experience within law enforcement. And the reason why I say that is because we rely on encryption to actually send information out. We rely on encryption to actually communicate within a secure platform. And within my experience of dealing, first of all, with counter-terrorism and organised crime, there's always other ways to actually investigate that type of crime. There's always other ways to generate sources. In relation to the digital child exploitation, there's also other ways to actually investigate those crime types. What I would like to see in New Zealand context is better laws that allow us to have better powers to investigate this crime, but not backdoors to encryption. Better education going towards our judiciary and our court services, and also better ability to use independent from prosecution and defence to verify the tools that we use, so the court can be actually really well informed that what we say is actually happening, and that our tools are not being released, but there is a process in place. And I think that's what we should be looking at in New Zealand in relation to digital crime.
Cheryl, would you like to comment on that? Not as John, do you have any thoughts on the ways in which law enforcement are using the powers? I mean, one of the risks, I suppose, with getting a technological solution to these social problems is that maybe we make it too easy. They reach for that too readily. I don't know if Spark does, or the extent of Spark's transparency reporting, or if it does do transparency reporting, but do you think that there is enough visibility over the ways in which law enforcement and intelligence agencies use these warrant powers and tools?
There's a few questions tied up in there. So, look, we are working on some transparency reporting of our own. That's something that we want to do and we think our customers will value. And to answer your last question, I don't think culturally yet the security agencies are, I don't think they're transparent enough, and they're not there culturally yet to be open to that. I think they're on the journey. They do want to be. Because what I would say is interception and decryption, we're talking about incredibly rare events. You know, in Spark we get to see, I guess, a proportion of the activity that goes on, and it's not common. Your average New Zealander, I suspect, way overestimates how much activity there is going on and how much and what type of information gets requested. So I guess, going back to the question though, and the question before, I still, our experience is if you can set principles, clear principles in legislation, and try not to dictate technology or technological solutions, typically as a service provider, we can work with law enforcement and security agencies and come up with a pragmatic answer for most of what they want. They don't get what they want today 100%, and they won't get it 100% of the time in the future, and I don't think anyone of them would say they want decryption of every piece of data going across the internet. But I do have I think those examples of countries where going down the route of trying to choose the answer and the technology solution for service providers who do this, day to day, will end in trouble.
Cheryl reached for the mic at the sound of the word transparency, I think.
Yes, I just wanted to comment on the question of whether the intelligence and security agencies could be more transparent, and I think they are adapting to a new environment and are becoming more transparent, but certainly there is a long way to go yet. And for example, on the question around what warrants are issued for the kind of activities that we're talking about, both agencies release a total number for each year of warrants issued, but other than breaking down into foreign and domestic for the NZSIS, there isn't any further categorisation of those warrants, and I think there's certainly room for more transparency around we're getting lawful authority to do certain things. What are those categories of things that we're doing?
Thanks. And I think what John's saying is that if there was more transparency, it's likely that people would be less concerned because they would see low volumes sparing use of these quite extensive powers. We'll go to the questioner here. You have the mic. Thanks.
Matt Stevens. I want to just pose a thought. We've already got situations where we've got Facebook and Gmail, for example, offering encryption apps to people of New Zealand. And listening to the panel, we don't have the ability ourselves, given that we're in the middle of a tech hub in Wellington, to actually make similar applications and offer the similar sorts of services. And if you tie that into worries about sending our personal data overseas to foreign companies to capitalise, is there scope to enable some of those businesses to grow and develop within New Zealand?
Ryan, do you want to take this one?
Yes. No, absolutely, because right now we have a few platform providers. One of them is Zero, for example, or even we have Rivera trying to do something. So it was just released yesterday. Rivera with Nereid, a Cambridge-based, Waikato-based company working on a blockchain approach in the file system to promote accountability and transparency. And it's going to be used for major account holders such as governments. So the area is booming. For example, the team that I'm leading, we're also funded by MB, $12 million over 6 years to work on returning control, ultimately creating a kill switch kind of technology which can be exported. So there's a lot of activity going on here, and we feel that there is a chance for New Zealand to be, as quoting Paul Ash from National Cyber Policy Office, for New Zealand to be a trust superpower.
Thanks.
Kind of in the same way as Switzerland and Ireland.
We made it 80 minutes before the first mention of blockchain, so I'm taking that as a win. So we have another question in the front here, Sophie. Thanks.
My question's about oversight, mainly to Cheryl and to some extent Thomas. What confidence do we have in the oversight in New Zealand of both GCSB and law enforcement, particularly being that in America post-Snowden it was shown that the NSA were lying to their oversight committee continuously for a number of years? Do we have faith that oversight in New Zealand is robust enough and that none of our agencies have gone rogue and are doing their own thing and lying to the oversight committee? So to some extent a question for Thomas is, do you trust the oversight committee? And to Cheryl, why should we trust the oversight committee?
I'll answer first, I guess then. From what I can tell from the complete outside, I've got no insider context at all, oversight does seem to be improving at least. But to my mind, there are still a lot of questions I don't know the answer to, and I'd kind of like to know the answer to feel safer about what they're doing and what's happening and so on. I mentioned before, I can't remember the name of some of the the ways they've got of getting certain some of the warrants available in the surveillance in the spying act. Sorry, I still don't really understand them and how they're used and what they're for. And if I don't, I'm going to assume that most other people don't as well. And I would really appreciate from those agencies a much more full explanation. But the communications we have with them, they're always trying to defend. They're always trying to produce the minimum. And it's that sort of attitude we have to get rid of. I mean, I think we should know, for example, that the SAS maybe has, if they do, they've got links into a number of companies and government departments and how they can access those. Yes, we've got a link into the ID, but we have to get a warrant first to actually use that link. And being able to explain to that level, that's not going to really, I believe, weaken our security, but it would help explain a lot to us about what's actually happening and so on.
I guess ultimately someone other than me is going to have to assess whether our oversight is effective, but what I can say is that the Inspector General and my staff all have complete access to all information held by both the NZSIS and the GCSB. We have a statutory right to access all of that information, and we do use that right quite rigorously. The quid pro quo is that we also are subject to the same obligations of confidentiality as the agency, so we can't disclose classified information, at least not without the consent of the agencies. But what I can say is that we have consistent with an office of 8 people, we have a rigorous program of, one, dealing with complaints from the public about the agencies, but probably more significantly, we review every single intelligence warrant that is issued to both agencies, and we look both at the kind of documentation, but also often look more deeply. So we'll go and look at what was the intelligence case for seeking the warrant, what was the intelligence gained under the warrant, how was it reported back to the minister, and make that kind of evaluation. And we also, again, consistent with only 8 people, we review on a rolling basis various aspects of the operational activities of both agencies. So we'll go into a particular area of the GCSB, for example, and say we want to look at this activity over this period. And we have access to all information and to all of the staff to talk to them about it. Now, we can't look at everything. We don't review every decision. So is it possible that things happen without us knowing? Yes, of course. But I'm confident that combination of our powers and what I have seen of the willingness and in fact keenness of the agencies to comply with the law, that there's not a lot that we miss, I think, and I do emphasise that in my experience both agencies are keen to comply with the law. Doesn't mean they don't make mistakes, but that's a different question. But like Thomas, I think although the new legislation is an improvement, it would be preferable to have some of those powers about what the agencies can do spelled out in a lot more detail.
If I can make a quick comment on that, as someone that deals with them and on behalf of an organisation that deals with them, I think most New Zealanders would be proud of the work they do and how they do it. They are very focused on what is reasonable and proportionate use of their powers. Again, same point as before. They could be more transparent in building that trust, but from what we see, they do a very good job of staying on the right side of the line.
Thank you. By my calculations, we've got about 2 minutes left, so we could take one quick question if anybody's desperate to take advantage of this expert panel. I've got a blind spot, so I can't see if anyone's behind the pillar there. We have none. Then I will close our session, and thank you so much for coming and engaging in this topic of great contemporary importance. And I think that we all find ourselves now better prepared to engage in the discussion when it inevitably lands on the political and public agenda. I don't think this will be the last event. We've heralded that we've got some challenges coming. There are applications that are available that are outside the warrant regime. There will be pressure to access those. We have technologies that are going to transform our current understanding of technical security, and we'll need to reconvene and discuss how we do that. But I want to thank our panellists for giving up their time and technical expertise to contribute to this discussion. But before I ask you to join me with a round of applause, I also want to thank my staff who have organised this event over the last few months. Charles and his team, Vanessa and Sophie with the microphones, Julie and Sharon with admin. It's not easy, and we're very grateful to them and to you for making it a success. So thank you so much.